one judge, multiple defendants, bond battles, delays, and non-stop pressure.
Calls the case, People versus Dominique White.
Ally's on behalf of the people, Your Honor.
I did.
Did you? Oh, okay, never mind, my bad. Oh, I see it.
That is on behalf of Mr. White. Can you state your name for the record?
Dominique White, yeah. All right, thank you. What are we doing?
Your Honor, today is a preliminary examination. At this time, I would be asking the court to add a count 2 of domestic violence second offense with the PAC code 750.813. And people would be unable to proceed as count 1, would ask that count 2 be remanded to district court.
Okay, so part of that's going to be a bit of a problem in doing that this way. We did it before. I did it before. And theoretically, I would need a new complaint with that charge on it. I don't mind sending the defendant. Can you get that done quickly?
Yes.
Okay, so what I'll do is let me pass the matter, get that done so that I have that complaint before me. Is there going to be any objection to the adding of that charge?
No, Your Honor.
All right. Okay, so then we can do that so that he can properly know what the charges are.
Okay.
Because, all right.
So, okay.
The next one, is this one also in custody?
Is it custody, Your Honor?
But not on here.
Correct, back here.
Okay. Are they bringing him right back up?
No.
No? Okay. Then I'll do this one. Court does call the case People versus Antonio Cornelius.
Yes, Your Honor. I think this is Mr. Ward's case.
Marie Tanhouse, the prosecuting attorney, standing in for Mr. Ward, and Phil Owen, he's on the way.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Cornelius, who stands to my right. Please state your name for the record, sir.
Antonio Cornelius.
Zachary Ward on behalf of the people.
All right, they have before me a plea form. Is that what we're doing?
Yes, Your Honor.
Your Honor, the defendant will be pleading guilty to count 3 as charged, as well as adding count 4.
Well, the form doesn't, that's what I'm trying to figure out,
Okay.
because it doesn't say that, but it says the count 4, but not count 3.
Where would I add that?
Anywhere would have been better than nowhere.
You could handwrite that. The defendant would also be pleading.
Well, yes, I'll be more than happy
Yes.
to do your job.
I'm rusty, Your Honor. I'm not here to-
All right, it's the court's understanding that the plea agreement form that the defendant is going to be pleading to guilty to the stated count 3 of malicious destruction of personal property, 200 to 1,000, the 1-year offense, and also an added count 4 of attempted resisting and obstructing the 1-year offense. Upon his successful plea to those charges, counts 1 and 2 would be dismissed. And there is a consent by the prosecutor to HIDA. That is the court's full understanding of it.
Yes, Your Honor. Yes, Your Honor. That is the agreement that I have discussed with my client. He would like to accept that offer today.
May I have him sworn?
Raise your right hand. Solemnly swear and affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God. State your name.
Antonio Cornelius.
Stated his name. Sure. All right. Sir, it is this court's understanding that you're going to be pleading guilty to 2 misdemeanor charges. Is that your understanding?
No.
Is that your understanding, Mr. Cornelius?
Yes.
Sir, do you want to enter these pleas?
Yes.
Are you going to answer my questions then?
Yes.
You understand that you'll be pleading guilty to 2 misdemeanor charges?
Yes, Your Honor.
Counsel approach, please. Record should reflect that we've had a bench conference in the Cornelius matter. I'm going to pass the matter briefly, let him have a conversation with counsel, and then let us know when you're ready and call you back up.
Thank you, Your Honor.
Who is that?
There's no one at the-
There's no one.
There's no one right there.
Okay, never mind. They may be next door, dude. Whatever, but that's okay. Court does call the case People versus Jeffrey Moore.
Jeffrey Moore, on behalf of the people.
Assistant Public Defender Van Denver, on behalf of Mr. Moore, who is standing to my right. Mr. Moore, would you state your name for the record, please? Jeffrey Moore.
Your Honor, this is the time set for the preliminary exam. This matter at this time, the people are unable to proceed.
Defense moves to dismiss.
People being unable to proceed, this case is dismissed on plaintiff, on defendant's motion.
Thank you.
Thank you.
Thank you.
They have Ryan Hackler, Your Honor.
All right. Court does call the case People versus Allen Ryan Hackle.
Jeffrey Moore, on behalf of the people. Negotiate.
Emma Dadush on behalf of Mr. Ryan Hackle.
Your name, sir? Alan Gordon Ryan Hackle. Thank you.
Your Honor, the time set for the preliminary exam. This matter at this time, the people are unable to proceed.
Your Honor, defense moves to dismiss this case.
People being unable to proceed, this case is dismissed on defendant's motion. That's without prejudice. Thank you.
Your Honor.
Thank you, Your Honor. That's okay, Feaster. And did a much better job than you. No, she did a much more graceful than you've ever been. I just thought I'd let you know that. You know, I don't mean to call you out, but she did a great job. All right.
So this is a read, right?
I don't know.
Yeah, yes. You have two recalls. You have Dominique White, Lafarty, Griffith, on it. Those are recalls.
Okay, and what's that?
Remands, both of them. This is who they're getting now.
Court does call the case of People versus Michael McLean.
On behalf of the people, Your Honor.
Good afternoon, Assistant Public Defender Lauren Perry on behalf of Mr. McLean. I just may have one moment, Your Honor.
Sure.
I can still respond to that, okay?
Thank you, Your Honor.
The judge opens with a tough call, setting a $10,000 cash bond and locking in the next court date without hesitation. Then comes Brandon Clement's case. His attorney steps in, asking for 30 more days so Clement can get assessed and continue AA. The judge pushes back, questioning the delay, but finally resets the case for June 5th, bond continuing for now. Next up, Troy Swope. His attorney wants a preliminary exam despite missing video evidence. The judge warns them, once the exam date is set, there will be no last-minute excuses. Swope agrees, and the judge schedules the exam for May 20th. Case after case hits the bench. Jeffrey Moore requests his own exam. Discovery complete, witnesses lined up, same date, same deadline. And then Megan Moses steps up. Her attorney wants time to go over a plea offer, but the judge is already frustrated with constant interruptions. It's a rapid-fire docket, and the judge keeps full control from the bench.
For a DV for $500, so I consider that he can't comply with court orders or his bond conditions, and I would ask that the bond remain the same.
Anything else?
What do you want to say?
I called Van Buren, sir, and they said that they don't have a holder on me.
What?
I got a number for Van Buren Courthouse, and they said they do not have a holder on me. I was let go in COVID with the certificate. That was during my marriage so many years ago. 19.
I don't know anything about the Van Buren case. I don't know anything about the Van Buren case, but he's making representations to the court that he contacted them and he doesn't have a hold there.
Yeah.
Sorry. Defendant's already violated his bond conditions before this court, which is why he is where he is right now. And did it in spectacular fashion in terms of just a number of calls. So the very fact that she's not here may not be a surprise because of some of those calls that were coming through. So at this point, what I'm going to do is I'm going to deny any request to reduce his bond, let him go through the process, and then maybe Judge Perry will feel differently about that, but I don't. So motion for bond reduction is denied.
Thank you.
Court does call the case, People versus Quanisha Thomas.
Grab my client out of the hallway.
Allie said on behalf of the people, Your Honor.
Or you can ask him to come in, don't grab anybody.
Can't step in for that one.
What?
Can't step in for that one.
Paid go.
Thank you, Judge.
Yep.
Good afternoon, Your Honor. Sydney Russian appearing on behalf of Ms. Thomas, who appears to my right. Please state your name for the record. Quanisha Thomas. Thank you.
Your Honor, today is the date and time set for preliminary examination. At this time, the people are unable to proceed as to counts 1 and 2, but ask that count 3 be remanded to district court.
Your Honor, we agree with that.
Okay.
They can't move forward.
I'll continue a not guilty plea as to count 3. Counts 1 and 2 are dismissed, the people being unable to proceed. We'll set a pretrial date,
May 15th at 9 a.m. before Judge Barr.
May 15th, 2025, 9 a.m. before Judge Barr.
Thank you so much, Your Honor.
Thank you. Bond will continue with its conditions. Thank you.
Thank you. Have a great day, Judge.
You do the same. All right, I got one in back.
So other than your 2 calls, I'm of the impression everything else is holding.
So how many is that?
4, 1, 2, 4.
4?
I think. Yeah, 4.
Okay. Ms. Pate, are you ready on yours?
Yes, Your Honor.
All right, let's try to get that one out of the way.
Okay.
Then I don't, why did we pass it? Oh, that's right.
Oh, okay.
Pardon?
Sending it right now.
It's okay. You're working hard. I can't depend on everybody for that, but I know I can depend on you for that. Court does recall the case People versus Antonio Cornelius.
Zachary Wood on behalf of the people.
Wow. Was that a sneeze or just a scream? That hurt my ears.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Cornelius, he stands to my right. Please state your name for the record, sir.
Antonio Cornelius.
All right, and I have had him sworn. And so we were in the middle of a plea, and sir, my understanding is that you wanted to take advantage of this plea offer, is that correct?
Yes, Your Honor.
All right. And you understand that you'll be pleading guilty to 2 misdemeanors?
Yes.
All right. First of all, this court's understanding you'll be pleading guilty to the charge of malicious destruction of personal property, 200 to 1,000. That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. The fine could be increased if 3 times the value of the property destroyed. If that's greater than $2,000, that would become the maximum fine. You understand that, sir?
Yes.
All right. Also, that you'd be pleading guilty to an added count 4 of attempted resisting and obstructing a police officer. That's a misdemeanor punishable by up to 1 year incarceration, a $1,000 fine plus court costs. You understand that?
Yes, Your Honor.
All right. Now, understanding all of that, you still wish to plead guilty to these charges?
Yes.
All right. To the charge of malicious destruction of personal property, how do you plead?
Guilty.
To the charge of attempted resisting and obstructing, how do you plead?
Guilty.
And you understand that by pleading guilty, you will not have a trial of any kind.
Yes.
You signed an advice of rights for today, is that correct?
Yes.
Any question regarding any of those rights?
No, Your Honor.
Please look at paragraph 5. You'll see a copy on the podium there. Those are your rights, which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
Not this time.
Has anybody promised you anything other than what's been stated here today to get you to plead to these charges?
No.
Anybody threaten you or coerce you in any way?
No. No.
You're doing this voluntarily and of your own free will?
Yes, Your Honor.
And also because you believe that you're guilty of these offenses?
Yes, Your Honor.
On the date of March 5th, 2025, at the location of 2281 Bonesteel Boulevard, City of Ann Arbor, Washtenaw County, State of Michigan. What did you do regarding the personal property of a Jonathan West?
Broke someone's headphones without permission.
Pardon?
Broke somebody's headphones without permission.
Okay, so you got their headphones and when you say you broke them, what did you do?
Attempted to snap them in half.
Say again?
Attempted to break them.
Just break them?
Yeah.
All right. And you didn't have their permission to do that?
I did not have permission to do that.
All right. And you didn't have any property interest in these headphones, meaning you didn't own them at all, did you?
No intent of theft.
Pardon?
No intent of theft.
He asked if you owned them. Were they your headphones?
Did not own the headphones.
Okay. And these headphones, are you disputing that they had a value in excess of $200?
Yes.
You are disputing that?
No.
Okay, so that maybe I asked the question badly.
I'm not disputing.
You're not disputing that they were worth more than $200.